Why did the ICC reject the request to hold the hearings in Kenya or in Tanzania?
The judges of the International Criminal Court decided in a plenary session where 14 judges were present that the commencement of the trial in the case against Mr. Ruto and Mr. Sang shall be at the ICC headquarters in The Hague in the Netherlands. So rejecting the joint defense application to move the hearings or part of the hearings to Tanzania or to Kenya. The judges, in principle, were in favor of bringing the hearings closer to the affected communities and to the locations where the crimes took place. But the vote did not reach the two-thirds majority that is required in order to change temporarily the seat of the court. The opposing judges considered that indeed we have to continue with the general rule, which is that the ICC hearings are conducted at the ICC headquarters in The Hague. The vote was conducted after a thorough examination by the judges of the different observations submitted by the parties, by the registrar, by the relevant authorities on the feasibility and the need whether or not to move the hearings to Kenya or to Tanzania. And the judges also took into consideration a large number of factors such as security, the impact on the security of the witnesses or of the victims, the impact on the way the ICC is perceived, and also the capacity of the court to continue conducting other proceedings related to other cases, and how long possible hearings would be taking, whether in Kenya or in Tanzania. So all these factors were taken into consideration. And as I said, there was no sufficient majority to decide to move the hearings to Kenya or to Tanzania. Two judges appointed or added separate opinions where they explained why they were voting for this move of the hearings. But as we said, there was no sufficient majority, and so the trial will commence and will continue at the ICC headquarters.
Will the President and the Deputy President of Kenya be simultaneously present in The Hague for the proceedings in the two cases?
Let me start by clarifying that Mr. Ruto, Mr. Sang, Mr. Kenyatta, they are not prosecuted by the ICC in relation to their official capacities or to their political positions. The proceedings are related to their alleged individual and personal criminal responsibility regarding the post-elections violences in Kenya in 2007 and in 2008. As you know, the trial is scheduled to start on the 10th of September in the case of Mr. Ruto and Mr. Sang, and the 12th of November for the case of Mr. Kenyatta. The ICC judges have not yet established the full schedule of the hearings. But in establishing that, the judges will take into consideration different factors, including the submissions of the defense of Mr. Ruto and Mr. Sang to have breaks in the proceedings and to alternate between the two cases by blocks of 2 or 3 weeks. This is one of the elements that will be taken into consideration by the ICC judges.
What did the appeals chamber decide regarding Mr. Ruto's presence at the hearing?
Let us recall that on the 18th of June 2013, the trial chamber decided to excuse Mr. Ruto from being present throughout the trial for him and for Mr. Sang, except for specified important and crucial hearings. The prosecutor has appealed this decision that has been issued by the trial chamber. So we are waiting now for the appeals chamber to make a finding on whether Mr. Ruto should be or not excused from being present except for the specified hearings. But the appeals chamber decided to suspend the effect of the trial chamber decision for the time being and until we have a final determination. That means that the trial chamber decision will not be implemented at this stage, and Mr. Ruto will thus be requested to be present physically before the ICC judges at all the hearings until the appeals chamber make a final determination, while allowing him to be excused or not. So for the time being, he will be requested to be present. The appeal chamber will make a final determination on the excusal of Mr. Ruto in due course. And it's important to say that this suspension of the trial chamber decision is with no bearing, with no prejudice to what the appeal chamber will decide on the substance, on the merits of the appeal.
Will the accused persons be detained when they appear before the court for the commencement of the trial?
No, the accused person will not be detained when they will appear before the IC judges for the trial. There was no arrest warrants against any of the Kenyan accused. They were only summoned to appear before the judges when there are hearings. So they continue to be free as they were all the time, complying with the IC judges' orders and conditions.
During judicial breaks or recess, can the accused return to Kenya, or do they have to stay in The Hague until the next phase of the trial?
The Kenyan accused are requested to be present before the IC judges when there are hearings. This is also the case for Mr. Ruto, pending a final determination by the appeal chamber whether he can be excused or not from being present. But for the time being, he and the other accused are requested to be present when there are hearings. But they will not be in detention. There are no arrest warrants against them. They continue to be free, and there is no restriction for on their freedom. They will only have to be present before the IC judges when there are hearings. When there are not hearings, they continue to be free.
Will there be any breaks when the trials begin, or they will continue uninterrupted?
The hearing schedule will be established by the IC judges, taking into account several factors. Among them, the observations of the parties, the logistic matters related to the presence of the witnesses and the length of their testimonies, the judicial recess and official holidays, the availability of the ICC courtrooms, and the compatibility of these schedules with other ongoing proceedings in other cases, etc. So this has not been yet established by the judges. It will be established in due course for the two cases. And at this stage, we cannot speculate on the length of the continuous hearings or the duration of the breaks, especially that even when the schedule will be established, it will be always subject to possible modifications by the judges, taking into consideration the factors that we just mentioned.